The next case for argument is 25-0272 Northwest Baptist Church of Cocoa Incorporated et al. Versus the Trustee Corporation of the King Street Baptist Church. We'll pause for a few moments as council make their way. All right. And for purposes of appellants, will one counsel be handling all? Is there more than one counsel? I see two counsel. Is just one counsel addressing the argument?
For appellee, it is, yes.
For appellee? All right, sir. And then for appellants, 5 minutes. Is that sufficient for?
10, please.
10 for rebuttal?
Yes.
All right, sir. We'll reserve 10 minutes for rebuttal. And you're welcome to proceed when you're ready.
Owners, good afternoon. My name is Mike Minett. I represent the appellants who are the defendants in the lower court. May it please the court. So I wish to point out a few essential facts which give context to the case from our perspective. Initially, King Street Baptist Church purchased the subject property that is in the dispute in this case in 1989. And with that deed, when it purchased the property, there was a reverter attached as page 2. That reverter is the first time it was entered into the chain of title at that time. And the deed indicates that if a majority of the church members of a church that has title to the property at any time in the future, if that majority fails to adhere to, maintain, and propagate the doctrines, faith, and practices of the missionary Baptist churches, which cooperate with the Florida Baptist Convention and the Southern Baptist Convention, that represents a trigger of the reverter. So if there's no departure from the faith, there's no abandonment of the faith, as described in the text of the reverter, then there's not a triggering of the reverter.
And the court can decide whether there's been a departure from the faith?
I apologize.
The court can decide that?
The court cannot decide that. That is exactly right. The court would have to enter into a government-free zone for purposes of deciding religious-type issues, and therefore there's an entire body of law that we've, in the briefing process, we've set forth that indicates that the church autonomy doctrine prevents courts and any other form of government from answering the questions that are asked and presented in the reverter. So to that extent, Your Honor, moving directly to that, how can a court determine what propagation is of a doctrine? How about what is a doctrine? What is the faith and the practices of missionary Baptist churches? Just to answer any one of those questions would enter into that zone whereby courts are directed by the United States Supreme Court not to go because of the First Amendment. Kedroff is a case by the U.S. Supreme Court in 1957 which constitutionalized the concept that existed prior to that point, that said now, as of that date and that case, this concept of church autonomy is pursuant to the Constitution. There's two provisions in the First Amendment regarding freedom of religion, and both are triggered by this concept. So from the 1989 until 1997, King Street owned the property. Vacant property, and nothing was happening with the title to the property. There was no challenges to the reverter. King Street transferred the property to Northwest Baptist Church, 1997. On that transfer and that deed, it was a warranty deed that provided for King Street to transfer all of the interest that it owned in the property. It did not reserve any fractional interest, did not reserve any title claim to the property. All of the property, all the title to the property went to Northwest. So during the next 20 years after Northwest purchased the property, it fully developed the property with 2 large buildings, all the infrastructure, the connection to utilities, the parking lot, all of that was then not only built, but all of the construction loans were paid off. We have free and clear property with all these improvements on it after 20 years. In that 20th year, in 2017, King Street files its action. And on that day, it has to, at any point in time through that point in time, through the remainder of the case, it must be able to defend that it had standing on that day to bring the action. But as we argue in the briefing process, it did not have that standing. King Street never reacquired any interest in the property. It never, after it transferred all of its interest to Northwest, reacquired anything. But instead, it simply claimed that as a result of the reverter, that it had some basis by which to have standing in order to make its claim that the triggering had taken place and that it was the proper party to receive the title. If we look back at the terms of the reverter, it not only indicates that there must be this majority, that at a discrete point in time, that there was this lack of propagation, lack of following the doctrines of the faith and the principles of the Baptist Church. That means that there would be an analysis of who are all the members of the church, and then how many of them did not follow the criteria that is set forth in the reverter. In this case, there was never any final record of how many members and who they were of Northwest Baptist Church at a discrete point in time in order to determine whether there could be a majority or a minority. You can't do the math without knowing the full number of members. And I can also say that there is nothing in the record that through all the depositions that were taken in this case, there is no evidence that even one member renounced their faith. In fact, the folks that were involved in generating the notices and the discussion at the meeting that was part of this case, they were the testimony at the depositions were these people were men of great faith. They were people you can trust.
Are we not well into ecclesiastical matters at this point?
We are very well into ecclesiastical matters, Your Honor. So to dissect
Even questions of membership, that's ecclesiastical.
It's
Much less are men and women of faith. I mean, good heavens. Right? I mean, we are well into church autonomy. This court has no prerogative to delve into such matters, do we?
I couldn't agree more. I couldn't agree more. Let's add to Your Honor's comments, taking an internal document to this church and dissecting it for purposes of Robert's Rules of Order and going through the bylaws. If the court was to review the bylaws, you would see that every sentence has to do with faith and following Jesus and how to be a wonderful Christian in the church would then collectively come together to assemble, to praise God and use all its efforts to evangelize the neighborhood. All of those things are built into the documents which create this entity. So in addition to membership and what goes on when you come together and all the things that Your Honor had mentioned, there's just a multiplicity of areas where this goes. But it's directed initially by the reverter. The reverter is drafted in a way whereby all these questions of faith have to be answered.
In other words, it's the occurrence that would trigger the reverter is itself ecclesiastical.
It is.
I mean, that is, and that's what kind of I've been wrestling with the case, and I'm sure counsel will talk to us in that regard. It's not a modest doctrine. That is not a modest doctrine. The United States Supreme Court, it's embedded in the First Amendment to the U.S. Constitution. A recent case from the U.S. Fifth Circuit Court of Appeals, McCraney versus North American Mission Board, that was issued October 28 of 2025. When they reissued an opinion there, it goes through long predating our Constitution into Anglo-English history and the Crown and those sorts of things. How would we delve into such matters?
Courts deal with such matters by honoring the no government zone that the United States Supreme Court has said. If the questions to be asked throughout the entire proceeding, throughout all the issues that have to be addressed in a case, if any one of them crosses the line and enters into this not being able to solve that issue by virtue of secular law, then it becomes such that the court cannot address the issue. The court just simply cannot ask questions and then come up with a determination of those things that are non-secular. They are within the body of issues that are protected by the First Amendment. So what does a court do? It simply dismisses the matter without prejudice. Routinely, we see in all these cases when, in fact, the church autonomy doctrine is triggered, then the courts will dismiss and say, we cannot proceed. We cannot proceed. We cannot take another step because to do so would then violate the Constitution. So by doing that, the court simply backs up and says that the matter is dismissed without prejudice. If you wish to recreate your action in some other way that does not violate the church autonomy doctrine in the First Amendment, then you may do so, Mr. and Mrs. Plaintiff.
Were opportunities at amendment offered already in this case?
The last pleading was the third amendment. So there were 4 pleadings offered by the plaintiff. And so there were many, many motions that were heard by the court before that period of time. And certainly church autonomy was discussed. If we went back through this, I don't know how many pages of the record, but there must be hundreds that address just this issue. So the plaintiff had every opportunity to determine how it would proceed. The way this case is presented and packaged, it absolutely crosses boundaries into the First Amendment at many, many different opportunities, many different places.
All right, sir, and you are into your rebuttal time if you wish to continue or if you wish to reserve.
No, I will reserve. Thank you.
All right, sir.
Thank you, Your Honors. May it please the Court, Scott Wiederman here on behalf of Trustee Corporation of the King Street Baptist Church. The issue of the ecclesiastical doctrine is the ruse of the case, unfortunately. I agree completely that the courts do not have the ability to go into questioning whether or not there is a matter of the church itself that has to be determined. But that is not what the lower court found. The lower court found that the processes that were laid out and agreed to by all of the membership, be Robert's Rules of Order, the bylaws, the notice provisions. If we were here saying one of those provisions were unconstitutional or couldn't be entered into, we might be here in a different circumstance. But
How did the court get to the Robert's Rules of Order? Where did that come from?
comes from the bylaws.
What does it say in the bylaws?
The bylaws say that the church shall be governed by Robert's Rules of Order, meaning
A little more than that, right?
it does say a little bit more than that.
Unless it's inconsistent with the bylaws.
Unless it's
How do we
yes,
determine
sir.
that without going through the bylaws?
Because if the question is that Robert's Rules of Order says very specifically, Your Honor, that you have to ask the positive question along with the negative question, and then you skip the negative question. All in favor say aye. If you skip the all opposed say nay. Now you haven't followed the agreed upon process. There isn't anything else to ask.
We're going to follow Robert's Rules of Orders unless it's inconsistent with the bylaws.
Yes, sir.
So if it's inconsistent, we don't follow Robert's Rules of Orders. How do we know whether there's an inconsistency here without figuring out what these bylaws mean?
Because there's nothing preserved in the record that shows that anybody was acting inconsistent to any other portion of the bylaws. The bylaws aren't in question. Robert's Rules of Order is in question, and following Robert's Rules of Order is in question, and that's what the court said didn't get followed. So you would have to have an argument from the other side that said, hey, the bylaws are in contradiction to Robert's Rules, or the
That was my
notice
question
provisions.
originally. That never came up?
Never came up. It was, and in the video and in the arguments that have ever been made, we've been talking about the procedural question of did every member get notice? Is there an interest that didn't get notice, which the bylaws do require, which is uncontested? And then at the time of the vote, did the vote happen where all parties interested had their chance to say something? All in favor say aye, all opposed say nay. Every other vote that happened that day, in the video, the transcript, and everything that's ever come out, always asked the opposition. The one question that they avoided doing it was in closing the church and transferring the property. There's nothing in the bylaws that talks about it, and in fact, Epperson deals with it very closely. The Supreme Court case in Epperson says that if a faction of the church arrogates authority to itself, disrupts the organization, and sets at naught well-defined rules of the church order. The defined rules are Robert's Rules of Order, notice of a special meeting, and all members being there, or
How does
having the
the court-
opportunity to be heard.
How do we determine who's a member without getting into church doctrine?
You would have to, there would have to be something preserved in argument that says the people that were the minority, the 17 members who did their affidavit, who didn't get an opportunity to be heard, were not, and that's not anywhere. No different than we are not saying that the majority wasn't the majority at the meeting and were members.
But
The
if I heard Judge Blocker's question correctly, I think, and I don't want to speak for her, even addressing the question of membership entangles the court in ecclesiastical matters where we are not permitted to go.
Which is not part of anything reserved for this court or its determination. We're not arguing whether or not they were or weren't members.
Well,
She
I mean,
just, oh,
go ahead, please.
You just said that one of the issues is whether all members had notice.
Correct, Your Honor. And if we have this issue where it is admitted in deposition and in the transcripts and during argument that not all members, by appellant's side says not all members got notice of the meeting, they're saying on their own, we messed up the process. We agree the process is here, the process is everybody's supposed to get notice. Then the neutral principles of law then come into play and say, did it or did it not happen? You don't have to ask who's the member to know by their own admission they didn't notice everybody that was a member. That's on them.
So would, in the Carlton to King Street Baptist Church deed in 1989, it even talks about that if a majority of the congregation strays from the Baptist faith and message, I guess it wouldn't have been that in 2000, the Baptist faith.
Understood, Your Honor.
All right, so if the majority of that church strays from the Baptist faith, then the property reverts to the minority, who is the true membership, the
Yes, Your
true
Honor.
congregation.
Yes, Your Honor.
So even the question, does that have any bearing on this discussion?
Well, the only bearing on this.
Because true members would be those who hold to the Baptist faith and message, and whether or not somebody has the right to vote, and whether they're a member, we're having to evaluate who's a true member according to the Baptist faith and message, or no?
That is nowhere reserved for this hearing, nor is it part of this matter. No, Your Honor. You do not have to determine if who is a majority who follows the faith or who is a minority that follows the faith. That is absolutely not what we're here for. The order of the lower court said, that's for you all to decide. I'm not even going there. What I am going to say is the meeting by admission of the appellant is that not everybody got notice, and the Robert's Rules of Order wasn't followed because you didn't ask if everybody's saying nay. So
Okay,
you don't
so-
have to make that determination.
I understand what you're saying, but help me understand further then. So, Robert's Rules of Order, all in favor, aye. I guess the argument is that whoever was presiding over the meeting heard the ayes and then just rammed it through to conclusion.
That's exactly what they did. We
And
got
I
a
belie-
majority, so we're done.
And if I recall the transcript or the briefing correctly, did so with the purpose.
Yes, sir.
Okay. So whether or not Robert's Rules of Order was followed, first of all, the church autonomy doctrine was raised below, right?
Yes, Your Honor.
Raised here.
Yes, Your Honor.
All right, and your position is we don't need to address membership because the court decided based upon a neutral principle of law, which of course would take us outside of the church autonomy doctrine, that based on a neutral principle of law, we do not need to discuss membership because the Robert's Rules of Order were not followed because members were not given the right to vote. Some who would have voted nay were not given that opportunity. Have I heard you correctly?
In the meeting, that's correct.
But whether or not they are entitled to vote would be dependent upon membership, which may be dependent upon whether or not they cling to Baptist faith and message. Would it not?
It would not, because it was already determined by the bylaws that you have to follow this process. There's a difference between coming and saying that the Robert's Rules of Order is not somehow in the bylaws. And we need to determine if Robert's Rules of Order is proper in the Baptist faith for this church.
But
We're out of that.
So am I being too simplistic? And I invite you to tell me if I'm wrong.
Yes, sir.
whether or not someone is entitled to vote through the mechanism of Robert's Rules of Order would be dependent upon whether that person has strayed from the Baptist faith.
If that was going to be an argument after they had an opportunity to be heard, absolutely. But it's too simplistic in what the lower court ruled. The lower court rule says we have definitive, all parties agree what the notice provision says, and we're going to use Robert's rules. The court can get now into whether or not those rules were followed. Those rules have already been decided, ecclesiastical or not. We're not worried about that. We have a process now that everybody agreed to follow, and it didn't get followed. That's a neutral principle of law. No, the court doesn't have to determine if Robert's rules was or wasn't the proper thing to use, or whether there was a minority or not a minority. You have to determine if the court, or if neutral principles, when they didn't ask the question, did they even give the party that was the minority, if they weren't a member, an opportunity to be heard? And if you don't have an opportunity to be heard, you're done.
So hypothetically, a visitor walks in off the street, it's first time ever coming in the doors of the church, and there happens to be a business meeting. You can only challenge his or her right to vote after he's voted?
If they're not a member, then you would have right then and there, you would be able to say you're not a member. Never happened in this case, nor is it relevant. If they are a member, but the process wasn't followed, then you have the process that serves over their membership. We already agreed on the process. It would be like they also didn't determine who was the majority, Your Honor. So how do we know that there was even a majority membership in this vote?
So the relationship, say that again, the relationship between process, and I don't know if there's talking in the back, but it needs to stop. The relationship of process to membership. Talk to me about that.
So the process that everybody agrees to be governed by is not ecclesiastical. If that would be like saying in any church or any club, hierarchical, congregational, we agree we're going to govern ourselves one way. There has to be a neutral principle of law that can come in to say that you didn't follow the process that you yourself agreed to be governed by.
But in any other
That's not by the church.
organization, you're not making a profession of faith to become a member.
You're not making faith, but this is not about faith. This is about, did you or did you not get the process, due process, to have your say?
You're only entitled to process if you're a member.
And we don't know that the majority is nor the minority, but that's not before the court. No one even bothered to ask that. No one's arguing that. No one's saying they weren't. No one's saying they were. It's a simple question of, did you get your opportunity to be heard? That's neutral principles. If the church says we're going to honor Robert's rules and that's what is going to govern us, that may be ecclesiastical. Did you follow Robert's rules is the process to get that enforcement. You cannot have it for either side.
Why do you have standing to challenge whether Robert's rules were followed?
What was left out of the argument for the deed, Your Honor, is just below the reverter it says, and that said party of the first part, which is our client, King Street Baptist Church, does hereby fully warrant title of said land and will defend the same against the lawful claims of all persons whomsoever. If we don't have standing to defend the claims in the deed that we specifically said we would do, we couldn't even be here. I mean, the deed itself says so. The deed itself makes it the responsibility of my client who was the grantor of the deed to defend it. If there's no standing, then there's a problem. We can't do what we said we were going to do. We're not warranting it. Then we have the affidavits of the members of the church that are here that claim they're the minority, which we can't say they're not because that is ecclesiastical, which, by the way, isn't part of this appeal. It's not even being questioned. That's not even an issue. And then finally, Your Honor, we have the minority interest holders themselves that Epperson says if there's going to be this manifest injustice, we have to still deal with property in Florida and the rights of the property ownership. That part does have to be in question. And if we're not here asking or answering the question of whether or not there is this minority, are they the minority? Did you confer them on the minority? Which we can't do. You have to take it as the gospel that they are members. You have to start there. There would have to be something preserved. We don't even have, Your Honor, the 1530 preservation of any of these issues before the court. That's really one of the bigger issues overriding. This court has made it clear if you don't follow 1530 and don't preserve these matters, we can't hear it. But the process is the bigger key. If we cut through that first part and get right down to the issue, you have to be able to make sure that the due process of the rights that the parties agreed to be bound by are followed. That's not church. That is this court. That is the secular courts getting in and saying, wait a minute, you didn't follow what you said you're going to do. I'm not going to make a decision whether or not you can or can't or should or shouldn't follow that. That you already decided, but you didn't do what you said. So now I've got to send it back. And the moment it goes back, because there was no determination of a majority, there was no determination of a minority, then the deed couldn't transfer in the first place.
So
It
the final
stays with
judgment,
Northwest.
the final judgment negates the deeds, right?
It does.
Based on Robert's rules. Then there's an amended final judgment that goes farther than that and directs title be given to King Street.
Yes, Your
How
Honor.
does that happen?
Because if you immediately determine that the process, Robert's rules and the notice provisions weren't followed, then it stays in the Northwest Baptist Church. The members of the Northwest Baptist Church minority held another meeting, ratified their assignments to the King Street Baptist Church, which is in fact in the reverter clause where it should go, because let's not forget, the deed very specifically says it doesn't go anywhere if the King Street Baptist Church is still alive and well, and we all know they are. That's undisputed. So we question whether the deed should have changed in the first place, Your Honor. But the court said if it's still going to be in Northwest because the process didn't happen correctly, they recognized the assignments, didn't have to delve into whether the assignments were valid or not valid, or they were churchgoers or weren't, and then said because they said they are, it goes. That's not a question that this court should really hit either.
How do we know there's not other minority members who did not sign assignments?
Well, that's the exact issue, Your Honor. If there are, and there are any other minority members, then the first line of the deed says to have and to hold the same in fee simple forever and future to have and to hold in tract parcel, etc., even if they be the minority. The deed vested in the minority the moment it was signed, because it's safeguarding that if one person is still there and says they want it, they get it. That's the vesting. It vested the moment it was signed in the minority. We can't say, if it was even here on appeal, whether they were a minority following the tenets of the Baptist faith, Brevard Baptist Convention, Southern Baptist Convention. We can't go there. What we know is they didn't get notice, which would automatically, Your Honor, if you're right, and we don't know all of the minorities here, property stays right where it was. Can't go anywhere. The process wasn't followed. Then when they don't get to vote, the ones that were there that do claim minority membership, it stays there again. And if you don't even know who the majority is, and they didn't have the right to vote the majority because everybody didn't get notice, it still goes back and stays in Northwest Baptist Church. And the assignments and the future meeting that was held by the minority members that we do know of still want to be there. They've assigned their rights, all within their right to do so. The problem is that by not following the notice provision and the process, the deed couldn't have transferred to Brevard Baptist. You can't have both issues go wrong. If they followed the process, we might not be able to be here. They agreed to follow the notice provisions in the bylaws. It's uncontradicted that they didn't. They agreed to follow the provisions of Robert Rules of Order, which mandate all that don't approve say nay. They didn't do it. You can't now transfer the deed because we don't know if all of the members were there. We don't know if there's a minority. We have no idea who else wants to be there still to this day taking it on. This property reverts and stays where it was no matter what. That's the big issue.
So if, let's say that the noes were given an opportunity to vote,
Yes, sir.
and there was at least one, perhaps more, constituting a minority,
Yes, sir.
and your argument, potentially consistent with the reverter clause in the deed, is it goes to the minority. The property goes to the minority,
It
right?
was already vested in the minority from day one. Yes, Your Honor.
Now you have the minority disputing against the majority as to who owns the property, and each group claims ownership. You following me?
I do.
Who resolves that?
The church then would have to do that within itself, but we're not here for that. That's not what did happen.
I understand. I want to explore the
Sure.
reach of the church autonomy doctrine.
Absolutely,
In other
Your
words,
Honor.
you're dealing with real property. There are legal connotations to the ownership and recording and all those sorts of things with real property. If the minority says they own it and the majority says they own it, who resolves that?
Sure, it starts out by
Is it the Wild
congregational.
West? The courts just say, y'all deal with it?
No, sir. Starts out congregational, goes to Brevard Baptist, goes to the State Baptist, deacons, the groups then get themselves together to make that determination.
But under the
of that
Baptist
ownership.
faith, that church is autonomous.
I agree. It's a
Entirely. The
congregation.
Southern Baptist Convention doesn't direct that. Florida Baptist Convention?
They do get involved, though, Your Honor, if there are disputes
That's for
between membership.
that's for reconciliation, is it not?
Well,
That's not they don't get to decree who owns that property.
absolutely correct. They do not get to make the decree. They try to get involved to see if that dispute could be handled within the congregation. They become the mediator, if you will. They can't force it to happen, but they get involved to then have the discussion.
Can the Florida Baptist Convention force it?
No.
Can the
They-
Brevard Baptist Association force it?
No, sir.
So nobody can force it, they can all try to mediate.
They can all try to mediate and try to force it, which is why Epperson comes into play that deals with property rights within the state of Florida. And as long as we're dealing with neutral principles of law, the secular court gets to make a determination, which is what we have here. We don't have a question as to whether the faith was being followed. We have a question as to whether the procedure that everybody agreed to follow was or wasn't. The moment it wasn't, the property has to stay where it was. I'm not here telling this court that it's going to not happen all over again and we're not going to be worrying about where the property goes, except I know the appellant's church has already moved out and they're done with the church. But put that aside, the issue is, should it have moved at this point? We can then determine whether or not we have proper meetings. If internally they want to say who has still paid their dues, who hasn't paid their dues, who is following the faith, who isn't, that wasn't even what was attempted here. It's not even what was part of it. It is autonomous. It is congregational form of governance. That congregational form of governance required them to ask the nay, and it required them to give the right notice. When that didn't happen, that is exactly where this problem lies.
Do you contest that the church autonomy the ecclesiastical abstention doctrine applies to a congregation?
Absolutely would, Your Honor. Depending,
It would apply.
It would apply if we were dealing with an issue of ecclesiastical nature.
Understood.
If we were here saying you can't have Robert's rules in the Baptist church, then we would be here saying, I can't make the determination. The church already did. They said, both sides were going to use Robert's rules. What we can do is say it wasn't followed. You got to follow the rules that the church laid out. We can't question that they had that right.
All right, sir.
Thank you
very
all.
much.
Thank you very much. Appreciate your time.
Yes, sir. Counsel, you have 9 minutes, 40 seconds.
Thank you. Good afternoon again. I would characterize King Street's claims in this matter to attempt to manufacture a claim that doesn't exist. The issues that are associated with the reverter is one set of criteria. In the event that these criteria are met and is shown in a court of law, there's a triggering that occurs, and therefore there is a opportunity for the people who make the claim that are one of three that are mentioned in the reverter to then be the party or the recipient of the title. Those three parties are the people who Your Honor had addressed earlier, who are those who are still faithful, those who maintain the faith. If there's a minority of those, that's a group. And that group then has an opportunity, if in fact there is a group, it contemplates that there may not even be a group in the reverter. If there is a group, they have the opportunity to then receive title. If not, then there is Brevard Baptist, and if not, then there's Florida Baptist. There's three identified parties in the reverter to receive. They have the standing by which to point the finger and say, the criteria in the reverter has been met. It has been triggered. King Street is not one of them. King Street is another church. It happened to be in the chain of title that sold the property to Northwest. But I'll call it King Street is Church A, and Northwest is Church B. And so no one has claimed that the criteria of the reverter has been met. In fact, I mentioned earlier, and it hasn't been challenged, that not one person has been identified as a member who has renounced their faith or met the criteria of the reverter. Not one member. And so the reverter stands alone as the ability for someone other than the correct title holder to receive the title, to receive it for nothing, to claim that they get it because of the reverter. Now, the reverter is mentioned in every single pleading that Northwest offers, but it quickly then goes into, in the latter two pleadings, and the one we're discussing today is the Third Amendment, this long list of problems that occurred at a meeting. Well, this is a private church meeting in Northwest. King Street wasn't invited. It is a members-only meeting. And whatever happened in that meeting, first of all, it's protected by the First Amendment. And second of all, King Street has nothing to do with that meeting. King Street has no standing to say afterwards something went wrong with the meeting. Something that was mentioned by my opposing counsel, he said that we have agreed in the record that Robert's rules need to be followed. Let me mention two things. And I've not been the counsel for the defendants since the beginning of the case. I have been involved in the last 5 years, however. This is a 7-year, 8-year case. And so during that period of time, I can tell you there's been no waiver of the First Amendment, no waiver of the church autonomy doctrine, no waiver that King Street is held to be a proper party with standing in order to claim some right and title to the property, which has to be by way of the reverter. It can't be because Robert's rules was not followed in a membership-only meeting. Apologize, Your Honor, I'm reviewing some notes that I took. Thank you, Your Honors. If there's not any further questions.
All right, sir, thank you very much.
Thank you.
John, you can take a break. All right, thank you both for very well-prepared, well-presented arguments in that particular case. We will proceed forward to our